California is recognized.
Thank you, Mr. President. I call up amendment number 133.
The Senator is advised the Senate is currently in a quorum call.
I ask unanimous consent that the quorum call be vitiated.
Without objection.
Thank you, Mr. President. I'd like to call up amendment number 133 and would ask consent to lay aside the pending amendment.
Without objection. The clerk will report.
The Senator from California, Mrs. Feinstein, for herself and others, proposes an amendment numbered 133.
Thank you very much. I appreciate that. I ask unanimous consent that at the conclusion of my remarks, my amendment be set aside and that the Senate return to the previously pending business.
Without objection.
Thank you very much, Mr. President. I rise today to offer an amendment to strike the first-to-file provisions of this bill. I'm joined in this effort by my co-sponsors, Senator Risch, Majority Leader Reid, and Senators Crapo and Boxer. I also ask unanimous consent that Senator Ensign be added as a co-sponsor of the amendment.
Without objection.
Thank you. I know that the bill has contained these provisions for some time now, and I acknowledge that I have voted for different versions of it that contain these provisions. But I've heard more and more in the past 2 years from small inventors, startup companies, small businesses, venture capitalists, and yes, even large companies from all around our country, but especially in my state of California, that this proposed transition from our first-to-invent system to a first-to-file system would be severely harmful to innovation, and especially burdensome on small inventors, startups, and small businesses. And I have become convinced that it's the wrong thing to do. For the benefit of my colleagues who have not been so embroiled in this rather technical issue, let me provide a little background. For over a century, our country has awarded patents to the first inventor to come up with an idea, even if somebody else beat them to the patent office. A first-to-invent system. And we have done very well under the first-to-invent system. This bill would change that so that the first person to file an application to a patent for a particular invention would be entitled to that patent, even if another person actually created the invention first. And this is what's known as the first-to-file system. Now, the argument for first-to-file is made for transitioning, is that the rest of the world follows first-to-file, and this will harmonize our system with theirs. This is really supported by big companies who have already made it, who have an international presence. Therefore, I understand their support for first-to-file. But under first-to-invent, we have been the world's leader in innovation, and the first-to-file countries have been playing catch-up with our technological advances. So without all due respect, I wouldn't trade America's record of innovation for that of virtually any other country, or certainly any first-to-file country. The genius of America is inventions in small garages and labs, in great ideas that come from inspiration and perspiration in such settings and then take off. So many of America's leading companies, Hewlett-Packard, Apple, Google, even AT&T arising from Alexander Graham Bell's lab, for example, started in such settings and grew spectacularly, creating jobs for millions of Americans and lifting up our economy and standard of living. A coalition of affected small business groups, including the National Small Business Association and others, recently said, and I quote, that first-to-file disrupts the unique American startup ecosystem that has led to America's standing as the global innovation leader, end quote. It's critical, I believe, that we continue to protect and nurture this culture of innovation. And preserving the first-to-invent system that has helped foster it is essential to do this. Moreover, this bill would not actually harmonize our patent priority system with that of the rest of the world. Many first-to-file countries allow more extensive use of prior art to defeat a patent application and provide for greater prior user rights than this bill would provide. And Europe does not provide even the limited one-year publication grace period that this bill does. An important part of this debate are the changes that the bill makes to the so-called grace period that inventors have under United States current law. Presently, a person's right to their invention is also protected for 1 year from any of the following. 1, describing their invention in a printed publication. 2, making a public use of the invention. Or 3, offering the invention for sale. This is called the grace period, and it's critical to small inventors. 108 startups and small businesses wrote last year, and I quote, U.S. patent law has long allowed inventors a 1-year grace period so that they can develop, vet, and perfect their invention, begin commercialization, advance sales, seek investors and business partners, and obtain sufficient funds to prosecute the patent application. During that grace period, many inventors learn about starting a technology-based business for the first time. They must obtain investment capital. They often have to learn from outside patent counsel at considerable expense about patenting and related deadlines and how to set up confidentiality agreements. Many startups or small businesses are in a race against insolvency during this early stage. The grace period protects them during this period, and loss of patent rights due to any activities, information leaks or inadvertent unprotected disclosures prior to filing their patent applications. S-23 eliminates this grace period from offering an invention for sale or making a public use of it, leaving only a grace period from, quote, disclosure, end quote, of the invention. There are 2 problems with this. First, disclosure is not defined in the bill. This will generate litigation while the courts flesh out that term's meaning. While this plays out in the courts, there will be uncertainty about whether many inventions are patentable or not. This uncertainty will, in turn, chill investment, as venture capitalists will be reluctant to invest until they are confident that the inventor will be able to patent on their own invention. Secondly, because of this lack of definition, some patent lawyers interpret disclosure to mean a disclosure that is sufficiently detailed to enable a person of ordinary skill in the particular art to make the invented item. In practical terms, this means a patent application or a printed publication. Now, this does provide some protection to universities. It's true. They often publish about their inventions. However, it is scant protection for the small inventor. They don't publish about their inventions until they file a patent application. As the 108 small businesses put it, and I quote, no business willingly publishes complete technical disclosures that will tip off all competitors to a company's technological direction. Confidentiality is crucial to small companies, end quote. The grace period from offering for sale or public use really is critical for their protection. Eliminating it will, in the words of these small businesses, quote, practically gut the American 1-year grace period, end quote. The National Small Business Association wrote recently, and I quote, "The American first-to-invent grace period patent system has been a major mechanism for the dynamism of small business innovation. It is clear that the weak or entirely absent grace periods used in the rest of the world's first-to-file patent system throttle small business innovation and job creation," end quote. Our amendment would provide America's world-leading system. I'm also very concerned that first-to-file would proportionately disadvantage small companies and startups with limited resources. I've become convinced that this change would impede innovation and economic growth in our country, particularly harming the small, early-stage businesses that generate job growth. Obviously, the process of innovation starts with the generation of ideas. Small California companies and inventors have described to me, however, how most of these ideas ultimately do not pan out. Either testing or development proves that they're not feasible technologically, or they prove not to be viable economically. Unfortunately, first-to-file incentivizes inventors to race to the patent office to protect as many of their ideas as soon as possible, so they're not beaten to the punch by a rival. Thus, first-to-file will likely result in significant overfiling of these dead-end inventions, unnecessarily burdening both the Patent and Trademark Office and inventors. As Paul Michel, former Chief Judge of the Court of Appeals for the Federal Circuit, and Gregory Juneman, President of the International Federation of Professional and Technical Engineers, put it in a recent letter to the committee, and I quote, "As Canada recently experienced, a shift to a first-to-file system can stimulate mass filing of premature applications as inventors rush to beat the effective day or of the shift, or later filings by competitors," end quote. This presents a particular hardship for independent inventors, for startups, and for small businesses, which do not have the resources and volume to employ in-house counsel, but must instead rely on more costly outside counsel to file their patents. This added cost and time directed to filing for viable ideas that can build a patent portfolio and a business. At a time when the Patent and Trademark Office has a dramatic backlog of over 1 million patents waiting to be examined and a pendency time of some 3 years, Congress should be careful to ensure that any legislative changes will not increase patent filings that are untruthful. The counter-argument is made that a small inventor could file a cheap provisional patent application, and that's sufficient protection. However, patent lawyers who work with small clients have said that they advise their clients not to treat a provisional application any less seriously than a full patent application. If there is part of an invention that's left out of the provisional application, that application will not be protected. And the parts that are included in the provisional application will also be vulnerable under an attack that the inventor failed to disclose the best mode of the invention by leaving out necessary information. The argument is made that first-to-file will establish a simple, clear priority of competing patent applications. Proponents of first-to-file argue that it will eliminate costly, burdensome proceedings to determine who actually was the first to invent, which are known as interference proceedings. However, the reality is that this is not a significant problem under our current system. There are only about 50 interference proceedings a year to resolve who made the invention first. This is out of 480,000 patent applications that are submitted each year. In other words, 1/100th of 1% of patent applications. Another problem with the bill's first-to-file system is the difficulty of proving that someone copied your invention. The bill's proponents assert that it protects against one person copying another person's invention by allowing the first inventor to prove that, and I quote, such other patent was derived from the inventor of the invention, end quote. Currently, you, as a first inventor, can prove that you were first by presenting evidence that's in your control, your own records, contemporaneously documenting the development of your invention. But to prove that somebody else's patent application came from you under the bill, was derived from you, you would have to submit documents showing this copying. Only if there was a direct relationship between the two parties will the first inventor have such documents. If there was only an indirect relationship or an intermediary, for example, the first inventor described his invention at an angel investor presentation where he didn't know the identities of many in attendance, the documents that would show derivation, which means copying, are not going to be in the first inventor's possession. They would be in the second party's possession. You would have to find out who they talked to, who they emailed with, to trace it back to your original disclosure. But the bill doesn't provide for any discovery in these derivation proceedings. So the first inventor can't prove their claim. For these reasons and many others, the first to invent system, which I believe has made our nation the leader in the world, which our amendment would preserve, is supported by numerous people and businesses around the country, including the National Small Business Association, the Coalition for Patent Fairness, that's a coalition of large high-tech companies, the Institute of Electrical and Electronics Engineers, which has 395,000 members, the International Federation of Professional and Technical Engineers, AFL-CIO, the University of California System, the University of Kentucky, Paul Michel, the former Chief Judge of the United States Court of Appeals for the Federal Circuit, which plays a critical role in hearing appeals in patent cases, and the United States Business and Industry Council, American Innovators for Patent Reform, the National Association of Patent Practitioners, Professional Inventors Alliance, USA, Connect, a trade association for small technology and life science businesses, and many small inventors, as represented, for instance, in a letter signed by 108 startups and small businesses from all over the country. Mr. President, I ask unanimous consent that a copy of this letter be placed in the record directly following my remarks.
Without objection.
Thank you. Mr. President, I don't often agree with the organization Gun Owners of America, a group that thinks the National Rifle Association is too liberal. But I do agree with them on this issue. They are part of the coalition of 23 conservative organizations that wrote to the leaders about this, arguing, and I quote, "Our competitors should have to harmonize up to our superior intellectual property regime, rather than our having to weaken our patent system and harmonize down to their levels." There are many other signatories, but, you know, I think this is really a battle between the small inventor, the beginning in the garage, the Apple computer who was nowhere, who, through the first-to-invent system, was able to create one of the greatest companies in the world. America's great strength is the cutting edge of innovation, and the first-to-invent system has served us well. You know, if it isn't broke, don't change it. And I don't really believe it's broke. So I'm delighted to see that my co-sponsor, the distinguished senator from California, is also on the floor on this matter. I welcome her support, and I yield the floor.
Mr. President,
Senator from Utah.
I ask unanimous consent that the distinguished junior senator from California be permitted to make a unanimous consent request and put her statement on the record, and then I would ask that the remaining time be granted to me.
Without objection.
Will the chair just cut me off at 1 minute, please?
Senator from California is recognized.
All right. I want to thank Senator Hatch so much, and I want to thank my friend and colleague, Senator Feinstein, for this critical amendment. And I want to ask unanimous consent to place my statement in the record and conclude my remarks in this way. The Feinstein Amendment is necessary. It's necessary because the first person to invent a product should get the protection from the Patent Office. And we believe that if this amendment doesn't pass, it really goes against the express language of the Constitution, which awards patents to the inventor, not the fastest one to run down to the Patent Office. Senator Feinstein has explained why this is a matter of fairness, why it's better for consumers, and I'm very hopeful that her amendment does pass. Thank you very much. Again, thanks to Senator Hatch.
Thank you. Mr. President.
Without objections.
Mr. President.
So ordered. Senator from Utah.
Mr. President, I've been following the debate closely on the patent bill and wanted to again voice my strong support for the passage of this very important legislation. We've been working on this bill for a number of years, and it is satisfying to finally see the full Senate consider it at this time. As I've said before, the patent reform bill is about moving our nation forward towards the future. It will equip America's inventors with an improved patent system that will enable them to better compete in today's global economy. Toward that end, I would like to just take a minute or two to discuss some of the key provisions of this bill and what they will do to improve and modernize our patent system. There are some misconceptions about the proposed first-to-file provision. Some have questioned why we cannot maintain the current first-to-invent system in which priority is established by determining which applicant actually invented the claimed invention first. Under this system, the current system, if there is and by the way, the rest of the world has a first-to-file system. But under this system, if there is a dispute, it costs the applicants an average of $500,000 in legal fees to prove that they were the first to invent. This amount does not include extra expenses that can follow if the decision is appealed. Unfortunately, many small businesses and independent inventors do not have the resources to engage in the process we have now. Conversely, moving to a first inventor-to-file system would provide inventors a cost-effective and certain path to protect one's invention through the filing of a provisional application at a much more reasonable cost of about $100. Now, the purpose of the proposed transition is certainly not to hurt small businesses or independent inventors. Quite the contrary, these innovators are too important for our nation's economic health. But let's consider some facts. In the past 7 years, more than 3 million applications have been filed, and only 25 patents were granted to small entities that were the second inventor to file, but later proved that they were the first to invent. Of those 25, only 1 patent was granted to an individual inventor who was the second to file. Thus, in the last 7 years, only 1 inventor in over 3 million patent filings would have gotten a different outcome if we, like the rest of the world, used a first inventor-to-file patent system. Now, I assure you that I do not want to minimize the reluctance that some have with changing to this new system. However, the facts speak for themselves. Simply put, moving to a first inventor-to-file system does not appear to have the level of risk that some have feared. Additionally, the American Bar Association Section of Intellectual Property Law recently confirmed the importance of the proposed transition by stating, quote, "For inventions made after 1996, the U.S. patent system has been open to proofs of inventions made outside the United States, creating for many U.S.-based inventors a new and potentially even more expensive obstacle to obtaining a patent under the current first-to-invent rule. Finally, U.S. inventors more and more are facing the need to file patent applications both at home and abroad to remain competitive in our global economy. Requiring compliance with two fundamentally different systems places undue additional burdens on U.S. inventors and puts them at a competitive disadvantage in this global economy," unquote. Indeed, the transition from the first inventor-to-file system is long overdue and will help our U.S. companies and inventors outcompete their global challengers. The proposed legislation would also give the USPTO rulemaking authority to set or adjust its own fees without requiring a statutory change every time an adjustment is needed. Providing the USPTO the ability to adjust its own fees will give the agency greater flexibility and control, which in the long run will benefit inventors and businesses as well. Speaking of greater fiscal flexibility for the USPTO, let me take a moment to discuss the importance of ensuring full access to the fees the agency collects. American inventors who create jobs and keep our economic engine running should not have to wait for years after they have paid their fees to have their patent applications processed. Now, this is tantamount to a tax on innovation, and it creates disincentives for inventors and entrepreneurs. A fully funded USPTO with fiscal flexibility would, at the very least, mean more and better trained patent examiners, greater deployment of modern information technologies to address the agency's growing needs, and better access to complete libraries of prior art. Over the years, fee diversion has forced a vicious cycle of abrupt starts and stops in the hiring, training, and retention of qualified office personnel. To make matters worse, under current conditions, outdated computer systems are not keeping pace with the volume of work before the agency. Now, it's clear to most that the USPTO has yet to recover from the negative impact of diverting close to $1 billion from its coffers, from its own use. That's not only been wrong, it's obscene. I agree with what has been said that there cannot be true patent reform without full access to collected fees by the USPTO. Now, we owe it to our inventor community to do this. We all have a vested interest in ensuring that our country's unique spirit of ingenuity and innovation continues to thrive and flourish. Last night, an overwhelming majority of the Senate voted to finally put an end to fee diversion from the USPTO. It was a historic moment, and I hope our House colleagues will maintain this momentum. I understand that people on the Appropriations Committee didn't like it. Some people. They didn't like it because they like to be able to play with that money. But it is really disastrous to not have that money stay with the USPTO so that we can move forward faster and better and get a lot more done and still be the leading innovative nation in the world. Well, the legislation also enables patent holders to request a supplemental examination of a patent if new information arises after the initial examination. By establishing this new process, the USPTO would be asked to consider, reconsider, or correct information believed to be relevant to the patent. The request must be made before litigation commences. Therefore, supplemental examination cannot be used to remedy flaws first brought to light in the course of litigation, nor does it interfere with the court's ability to address inequitable conduct. That's a really important point. Further, this provision does not limit the USPTO's authority to investigate misconduct or to sanction bad actors. In a nutshell, the supplemental examination provision satisfies a long-felt need in the patent community to be able to identify whether a patent would be redeemed or would be deemed flawed if it ever went to litigation, and enables patentees to take corrective action. Now, this process enhances the quality of patents, thereby promoting greater certainty for patentees and the public. The America Invents Act also creates a mechanism for third parties to submit relevant information during the patent examination process. This provision would provide the USPTO with better information about the technology and claimed invention by leveraging the knowledge of the public. This will also help the agency increase the efficiency of examination and the quality of patents. The pending legislation also provides a new post-grant review opposition proceeding to enable early challenges to the validity of patents. This new but time-limited post-grant review procedure will help to enhance patent quality and restore confidence in the presumption of validity that comes with issued patents. Finally, this bipartisan patent bill provides improvements, many improvements to our patent system, which include, among other provisions, just some of the following. Changes to the best mode disclosure requirement. Increased incentives for government laboratories to commercialize inventions. Restrictions on false marking claims. Removal of restrictions on the residency of Federal Circuit judges. Clarification of tax strategy patents. Providing assistance to small businesses through a patent ombudsman program. Establishing additional USPTO satellite offices, and creation of a transnational post-grant proceeding specific to business method patents. Mr. President, as you can see, this bipartisan bill represents significant changes to our patent laws. They will enable our great country to more effectively compete in the 21st century global economy. So I encourage my colleagues to take action and vote in favor of this bill. We cannot afford to allow this opportunity to pass us by. Mr. President, I yield the floor.
Mr. President.
Senator from Minnesota.
Mr. President, I want to thank the senator from Utah for his strong statement of support for the America Invents Act, a bill that is at its heart all about moving our economy forward. When we think about the brass tacks of our country, we think about ideas, we think about inventions. It was our inventors who developed the light bulb, the assembly line, the Internet, the iPod, and of course my 15-year-old daughter's favorite invention, Facebook. And this all came from our great country. I wanted to just comment briefly, and then I know Senator Rockefeller has an important issue to talk about the issue that we've just been discussing up here. First of all, we've heard from stakeholders from across the spectrum, from high-tech and life sciences to universities and small inventors in support of the transition to the first-to-file system. At this time, I'd like to place in the record a list of supporters of the transition to the first-to-file system that is contained in the America Invents Act.
Without objection.
Thank you. We've heard also on the floor that there is, as Senator Hatch mentioned, strong support throughout the Senate for this change. In fact, Commerce Secretary Locke emphasizes that support in a column appearing in the Hill newspaper today. He states, quote, patent reform adopts the first-to-inventor-to-file standard as opposed to the current first-to-invent standard. First-inventor-to-file is used by the rest of the world and would be good for U.S. businesses, providing a more transparent and cost-effective process that puts them on a level playing field. I couldn't agree more. Small businesses, independent investors, and stakeholders across the spectrum support this important transition. And I just wanted to mention one other thing here about this system. With the current first to invent system, Mr. President, when two patents are filed around the same time for the same invention, it also creates problems. It means the applicants must go through an arduous and expensive process called an interference to determine which applicant will be awarded the patent. Small inventors rarely, if ever, win interference proceedings because the rules for interferences are often stacked in favor of companies that can spend more money. We believe this needs to change. There was a recent article about this in the Washington Post in which David J. Kapos, the director of the Patent Officer and Undersecretary of Commerce for Intellectual Property, described the current system as like parking your car in a metered space, then having someone else come up and say they had priority for that space, and then having your car towed. Instead, Mr. President, we need a system in which if you are the first to pull in and pay your fee, you can park there and no one else can claim it's their space. The America Invents Act would create that system. It transitions our patent system from a first-to-invent system to a first-inventor-to-file system. By simply using the filing date of an application to determine the true inventor, the bill increases the speed of the patent application process while also rewarding novel, cutting-edge innovations. A first-to-file system creates more certainty for inventors looking to see if an idea has already been patented. At the same time, the bill still provides a safe harbor of 1 year for inventors to go out and market their inventions before having to file for their patent. This grace period is one of the reasons our nation's top research universities, like the University of Minnesota, support the bill. The grace period protects professors who discuss their inventions with colleagues or publish them in journals before filing their patent application. Mr. President, with that, I know Senator Rockefeller is here to discuss a very important issue. Thank you.
Mr. President,
Senator from West Virginia.
I ask unanimous consent to set aside the pending amendments so that I may call up amendment number 134.
Mr. President.
Is there objection? Senator from Utah.
I have to object on behalf of the manager of the bill, who is not here right now, and if you could at least wait till Senator Grassley returns to make your same motion.
I know the senator from Utah was, and I would remind him that he was the lead author of the Hatch-Waxman Act creating the 180-day period for generics.
Object for right now, but as soon as Senator Grassley gets back, he's the manager of the bill.
Might I ask the senator from Utah, would he object if I talked about it?
No.
An objection was heard. The senator from West Virginia is recognized.
Mr. President, my amendment is based on the legislation I introduced earlier this year, obviously quite recently. The co-sponsors of that bill, which was called the Fair Prescription Drug Competition Act, were Senator Shaheen, Senator Leahy, who chairs the Judiciary Committee, Senator Inouye, Senator Stabenow, and Senator Schumer, who's on the Judiciary Committee. I want to acknowledge that the managers of this bill, Chairman Leahy and Chairman Grassley, have been steadfast partners in pushing the Fair Trade Commission to investigate further consumer access to generic drugs, which is a huge problem. We do a lot of talking about the health care bill and about a lot of other things about saving money and saving consumers money. And this is a bill which would do that if I were allowed to actually proceed to it. So this amendment eliminates one of the most widely abused loopholes that brand-name drug companies use to extend their shelf life, their monopoly, and limit consumer access to lower-cost generic drugs, which are in fact just as good, in fact just the same, but they have a nice system to work on that. It ends the marketing of so-called authorized generic drugs during the 180-day marketing exclusivity period that Congress did designate to give real low-cost generics a major incentive to enter the market. Now, what was happening was that the brand-name drug companies, they had their 18 years of exclusivity, and then the 18 years I mean, which is, that's a monopoly time unrivaled. And then somebody else would come in with a cheaper way of doing the same FDA-approved drug, but it would be a generic drug. So it would be the same drug, have the same effect, but it would be much, much cheaper. And since millions and millions of people buy these drugs, that would seem to be a good thing in a budget-conscious era for American families as well as for the government. So, as I say, this amendment ends the so-called authorized generic drugs during the 100-day marketing exclusivity period that Congress designated to give real low-cost generics a major incentive to enter the market. You have to be able to enter the market in order to compete and to get your lower-priced, equally good drugs out there. And they do that by challenging a brand name patent. That's the only way they can do it. An authorized generic drug is a brand name prescription drug produced by the same brand manufacturer, yet repackaged as a generic. Now, that's clever, but it's also a little devious. Many brand-name drug manufacturers are repackaging their drugs as generics for the purpose of extending their market shares after their patents expire. So they have a little subsidiary which produces something which they sort of shift over to them, and unfortunately this often eliminates the incentive for an independent generic firm to enter the marketplace, and thus the price of drugs remains much higher, and that would seem to be not in the interest of the American people. In 1984, Congress passed the Hatch-Waxman Act to provide consumer access to lower-cost generic drugs, and under the law, which the senator from Utah led, if a true generic firm successfully challenges a brand name patent, the generic firm is provided a 180-day period for that drug to exclusively enter the market. This is a crucial incentive for generic drug companies in order to enter that market and make prescription drugs more affordable for consumers. I mean, it would seem to me this would be a very laudable pursuit. Every American agrees on the need to reduce health care costs. Generic drugs save consumers an estimated total of $8 to $10 billion a year. $8 to $10 billion a year savings for the same quality of drug. And of course, they get that at the retail pharmacies where the prescription is handed out. For working families, these savings can make a huge difference, particularly during very tough economic times which we're going through. So this amendment would restore the main incentive generic drug companies have to challenge a brand name patent and enter the market. We give them the incentive to go ahead and challenge the brand name prescriber. So that's really what this is about. It's profoundly important. It's been before this body many, many times. And I guess it's a question of do we want to help people who have to take a lot of prescriptions, and older people, any kind of people, do we want to help them pay less? And I guess it divides into if you do or if you don't. I'm in the camp of, yes, I want to have people pay less, and so I will just say that. I make my comments, and I yield the floor for the time being.
Madam President,
The senator from Kansas.
Mr. Acting Presiding Officer, I think I